Now, the plaintiffs drew support in the New Jersey case and in other cases around the country from the state's Lead Poisoning Prevention Act. And almost all states now have some form of a lead poisoning prevention act that specifically says that if, as it did in New Jersey, that if there is a child with an elevated blood lead in a home that contains lead paint, that constitutes a public nuisance. And so the plaintiff said, so there, the state legislature itself has said that you can have a public nuisance. But what the court said is that unlike plaintiffs' complaints, our legislature's use of the term public nuisance in the Lead Paint Act is in keeping with the term's historical meaning and intent. And what they meant by that was that, as the court went on to say, we must conclude that the legislature, consistent with traditional public nuisance concept, recognized that the appropriate target of the abatement and enforcement scheme must be the premises owner whose conduct has effectively caused the nuisance. The court then went on to say, plaintiffs ignore the fact that the conduct that created the health crisis is the conduct of the premises owner. Plaintiffs would therefore separate conduct and location and thus eliminate entirely the concept of control of the nuisance. Essentially, the New Jersey Supreme Court went back to the origins of public nuisance and said you cannot shove this essentially a product liability act or action into the concept of public nuisance. The court further went on to say, in public nuisance terms then, were we to conclude that the plaintiffs has stated a claim, we would necessarily be concluding that the conduct of merely offering an everyday household product for sale can suffice for the purpose of interfering with a common right as we understand it. And then finally, the court said the inescapable fact is that carefully read, the claims asserted would instead be cognizable only as a products liability claim. And that's what we repeatedly argued in Rhode Island, that this is a products liability claim and should be brought under products liability theories that have been developed for 50 years, and ultimately the New Jersey Supreme Court, as we would contend correctly, agreed with us. And finally, there's the famous quote that you've heard a couple of times now. The court concluded we cannot help but agree with the observation, which was, by the way, our observation, that were we to find a cause of action here, nuisance law would become a monster that would devour in one gulp the entire law of tort. And that, ladies and gentlemen, we believe is the correct and what we hope ultimately the final word on public nuisance, although there are still many battlefronts going on. Fidelma also referred to the Wisconsin Supreme Court accepting public nuisance in lead pigment context. I believe it was actually the intermediate court. It has not reached the Wisconsin court. And there was a trial tried where the city of Milwaukee sued one of these companies. And it went to trial earlier this year for 3 or 4 weeks. And the defense won. The huge difference between the city of Milwaukee case and the Rhode Island case is that in Milwaukee, the court required that in order to find a public nuisance, the jury had to find some wrongful conduct on the part of the defendant. And in fact, the jury there did not find wrongful conduct in a unanimous decision and held that there was no liability for National Lead, now known as NL, one of the defendants. There is only one other case that I want to talk a little bit about that Joe raised, because it is also an important case bearing on many of these issues, which is the case out of the Supreme Court in California, the Clancy decision that was decided in 1985 that has now had some significant bearing on the public nuisance cases, especially in California. The Clancy decision dealt with a public nuisance action that was brought by I think it was the city of Corona, who retained contingent fee counsel to bring the action. Ultimately, the case worked its way to the California Supreme Court, and the California Supreme Court threw it out and held that in instances where a governmental entity is giving its police power, and I emphasize it's the police power, it's not the contractual kind of run-of-the-mill case, but when a governmental entity is enforcing its police power, it cannot do it on a contingent fee basis. The court said, we evaluate the propriety of a contingent fee agreement between a city government and a private attorney whom it hired to bring abatement actions under the city's nuisance ordinance. The court then said, when a government attorney has a personal interest in the litigation, the neutrality that is so essential to the system is violated. The court said there is a class of civil actions that demands the representative of the government to be absolutely neutral. This requirement precludes the use in such cases of contingent fee agreements. Now, ultimately, a number of governmental entities in California brought one of these lead pigment actions, including the cities of Oakland, Los Angeles, San Diego, San Francisco. It went through some 3 or 4 motions for demurrer with repleadings allowed. Ultimately, the trial court threw the case out. It went up to the 6th District. The 6th District reinstated the nuisance and fraud allegations. It went back, at which point we then moved that the contingent fee arrangement with the plaintiff's counsel had to be set aside under Clancy. The Superior Court agreed and held, given the inherent difficulties of determining whether and to what extent the prosecutor of this nuisance action might or will be influenced by the presence of outside counsel must be precluded from operating under a contingent fee agreement. That case then was appealed to the 6th District again, which is where it's at. So I think those are 2 of the really important decisions that put all of this into perspective. That 1, public nuisance is not appropriate for what is in every other court and probably every other day a relatively routine product liability action. But number 2, when it is a governmental entity that is seeking to enforce a public nuisance theory, whether against us or anyone else, the neutrality of the governmental entity is absolutely essential, and the contingent fee arrangement in that context is against public policy and should not be allowed. And my time is up, and I'll end it with that.
Thank you very much, Mike.